Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today on the podcast, I am very pleased that we're bringing you one of the first decisions about disability law that we've had recorded, which is very exciting. Right off the hop, I'm going to throw a content warning out there. This decision is about eugenics in Canada. It uses the R word a lot, quoted in the decision, and it involves a non-consensual medical sterilization. That can be very, very hard to read. If you don't want to engage and this isn't your thing, absolutely no problem. If you're listening, please take care while you're listening. It can be very heavy, especially when they get into the background of the eugenics board. And yeah, just take care while you're listening. And if it's not for you, no worries at all. So this decision, as we mentioned, hard stuff. And it was a woman who had a not great. It was sort of on the facts that her home life was pretty bad. And her parents sent her to a home for, quote, mental defectives when she was a very small child based on, sort of nothing. There was no testing. There was no doctor's opinion. There was no information that would suggest she needed a home like this. And then what had happened is when she was 12, the Eugenics Board of Alberta flagged her for sterilization, and she was sterilized against her will as an adolescent. And then as an adult, she brought a claim against the government. What ended up happening, she got a substantial award, which personally I don't think any award can sort of make up for what happened to her, but she got a substantial award, and they awarded all the types of damages except punitive damages. The judge held that, they're completely warranted. What happened to her was horrific and involved a board going against its own statute. But the government of Alberta waived the limitation of her claim. So she brought the claim as, an older adult, and she was obviously far past all limitations for anything. And the government waived all of those limitation periods. So because they did that, the court held that they shouldn't be punished for trying to make an actual amends as opposed to just sort of an apology with no action. The court sort of said, look, this is when apologies actually work, is when you shore up the apology with actual action, and we're not going to try to discourage the action.
Yeah, that makes sense in terms of like that discussion on punitive damages. I know I haven't read this case, and we were talking about it, just like the details of it. Like I can feel all my hair standing on end from like the shock and the trauma of this particular case. And I know like the way the law interacts with disability is, to put like gently, is problematic and has a lot of issues. And this isn't just like confined to a particular area or region. This is like a pan legal issue. And I think one of the things, at least to kind of bring up the mood of the conversation slightly, is the whole purpose of this podcast is to make the law more accessible, not just for the average person, but for persons who have disabilities or individuals who can't stare at a computer screen for very long or struggle to read cases because they're so long and wordy. So I think coming out of this type of drought in law, you find projects like this, like Canley, shout out to them,
obviously,
to try and make the legal information more accessible.
Definitely. And yeah, I would say I'd use harsher words than you to describe the law's interaction with people who have disabilities, but I won't on the podcast. But yeah, it can be very messy. I read this case in Law, Disability, and Social Change, which is a class that Windsor offers. I remember reading it in 2L and looking up that the Alberta Eugenics Board stopped existing in 1972. And I remember being so just disgusted that it took a while to process that information. If anybody's unfamiliar, eugenics is a horrible pseudoscience that racist people use to try to justify their own race being superior to others. And it was a way that essentially white people would sterilize sexually, among many other things, individuals who weren't white, right? And the decision goes into that pretty extensively, how rather than even following the mandate. So there was an act in Alberta called the Sexual Sterilization Act, which created the board, which was abolished in 1972. And the decision even explains how, they didn't even follow their own mandate. They essentially just sterilized whoever they didn't like. And there you go. And one of the most chilling parts of the decision is they have a doctor who was on the board testified, and she was a woman, and she had absolutely no qualms about what she did. She thought they were doing an actual progressive societal good. And I think that was the part that was the scariest, right? Because, sometimes, what do they say? The road to hell is paved with good intentions. It was very that sort of mode. It can be terrifying. It's scary stuff, and it's not fun to read, but I think it's important. And as you say, Zach, if we can fix one drop of the wrongs that have been done by the law to disabled people, persons with disabilities rather, over the last forever, then the whole project is worth it. So yeah, just reminder that we are definitely a accessibility forward project. And if anyone has any ideas how we can improve our accessibility, we are always open to those. One more content warning to be careful while you're listening to this. It is very hard to listen to, but I think very important to listen to, and we hope you enjoy. Muir and Alberta. Court of Queen's Bench of Alberta. Decision by Justice Veit. Summary. In 1959, the province wrongfully surgically sterilized Miss Muir and now acknowledges its obligation to pay damages to her. However, the province leaves to the court the determination of how much the province should pay. The sterilization was irreversible. The testimony of Miss Muir is supported by independent evidence and establishes that the physical and emotional damage inflicted by the operation was catastrophic for Miss Muir. This injury has haunted Miss Muir from the time she first learned what had been done through to the time when she fully realized the implications of the surgery. Her suffering continues even today and will continue far into the future. The court orders the province to pay her the maximum amount of damages for pain and suffering resulting from the sterilization allowed by the law, $250,280 as of September 1995, adjusted to the date of issue of these reasons. The damage inflicted by the sterilization was aggravated by the associated and wrongful stigmatization of Miss Muir as a moron, a high-grade mental defective. The stigma has humiliated Miss Muir every day of her life, in her relations with family and friends and with her employers, and it has marked her since she was admitted to the Provincial Training School for Mental Defectives on July 12, 1955, at the age of 10. Because of this humiliating categorization and treatment, the province will pay her an additional $125,000 as aggravated damages. The circumstances of Miss Muir's sterilization were so high-handed and so contemptuous of the statutory authority to effect sterilization, and were undertaken in an atmosphere that so little respected Miss Muir's human dignity that the community and court's sense of decency is offended. Were there no other relevant factors, the court would order the province to pay punitive damages to Miss Muir, not by way of compensation to her for the harm inflicted on her, but rather as punishment to the province of an additional $250,000. However, in this case, there are two reasons why punitive damages are not imposed. First, a large award has been made for aggravated damages. By itself, this award will be costly to the defendant. Second, the province voluntarily gave up what would have been a complete defense to Miss Muir's action. Miss Muir did not start her action soon enough. Had the province used this defense, called a limitations of actions defense, that would have put an end to Miss Muir's claim. The effect of choosing not to use this defense is more than equivalent to an apology. It constitutes a real attempt to make things right. As a matter of policy, government apologies and initiatives of this sort to redress historical wrongs should be encouraged. Punishing governments for their historical behavior would have the opposite effect. Miss Muir was admitted to the defendant's Provincial Training School for Mental Defectives on July 12, 1955, at the age of 10. She left the school without having been discharged and against the advice of the school's administration when she was nearly 21 years old, in March of 1965. The court finds that Miss Muir was improperly detained during this decade. The particular type of confinement of which Miss Muir was a victim resulted in many travesties to her young person. Loss of liberty, loss of reputation, humiliation, disgrace, pain and suffering, loss of enjoyment of life, loss of normal developmental experiences, loss of civil rights, loss of contact with family and friends, subjection to institutional discipline. The court awards her an additional $250,000 for the damages connected with the detention, plus prejudgment interest from 1965 to the issuance of these reasons. Ms. Muir claims additional aggravated damages of $125,000 relating to the detention because of the failure of the government's agents to adhere to the statutory requirements concerning admission, the use of school trainees, including Ms. Muir, as human guinea pigs for drug research, the connection between the sterilization and the detention, and other abuse conduct. These elements of aggravation have already been taken into account in awarding aggravated damages for the sterilization. No award is made for aggravated damages in relation to the confinement because this would be a duplication of the earlier award. Ms. Muir also claims substantial damages because during the time she was detained at the provincial training school, the government failed to provide her with the education and training she might otherwise have achieved. While Ms. Muir did have the ability to reach more than a grade 5 education, she has failed to prove that she has been and will be in a worse employment position as a result of the intervention of the province than she would have been had she remained out of the institution. As such, no award is made under this heading. Summary of award. Wrongful sterilization. Pain and suffering, $250,280. Aggravated damages, $125,000. Punitive damages, 0. Wrongful confinement, pain and suffering, $250,000. Interest thereon, $115,500. Aggravated damages, 0. Past and future loss of income, 0. Total, $740,780. Part 1. Background. Subpart A. Facts. Miss Muir was born in Calgary on July 15, 1944. Her mother, to whom I will refer in these reasons as Miss Skora, was in the 36th week of her pregnancy. Miss Skora was born in Poland and was raised Roman Catholic. She was 14 when she married for the first time. She married for the second time in 1942. Her husband was one EBD. When Miss Muir was born, Miss Skora was 20 years old. She had already given birth to 3 other children, one of whom had died. She was to have one other child, approximately 2 years after Miss Muir was born. Miss Skora's husband was away at war when Miss Muir was born. At the time, Miss Skora was living with Mr. H.G. Skora. In the application to have Miss Muir admitted to the Provincial Training School for Mental Defectives in 1953, Mr. Skora is described as Miss Muir's father. He stated that he was 19 years old when Miss Muir was born. Whether or not Mr. Skora was Miss Muir's biological father, he was certainly her psychological father. He was the only father she ever knew. In November 1964, when her husband died, Miss Skora married Mr. Skora. Mr. and Mrs. Skora subsequently separated. Miss Skora was alive when these proceedings were commenced, but she died before the trial. Mr. Skora also died before the trial. Miss Skora took Miss Muir to a provincial guidance clinic in October 1951. Miss Muir was 7 years old at the time. Miss Skora apparently gave Lilani's birth date as June 16, 1943. This is clearly wrong. It contradicts the evidence of the province's formal registration of birth document. Miss Skora apparently gave Lilani's prematurity as 7 months. This is also clearly wrong, as it contradicts the evidence of the province's form of registration of birth. Miss Skora informed the guidance clinic that she had been a heavy drinker until 1949. By implication, that's meant that she had been a heavy drinker during her pregnancy for Lilani. The staff of the guidance clinic at the time consisted of a family physician, a psychologist, and social worker, and a person referred to on the form as a psychiatrist. The evidence establishes that the person described as a psychiatrist, Dr. L.L. Levan, although a medical doctor, never received full accreditation as a psychiatrist in England or in Canada. The family had been referred to the guidance clinic because Leilani, quote, steals 3 or 4 lunches per day from school children, end quote. Although the school attended by Miss Muir and the name of Miss Muir's grade 1 teacher were known to the guidance clinic, there is no information about any intellectual delays suffered by Miss Muir. Indeed, nothing is reported about unusual conduct by Miss Muir except for her long-standing habit of stealing food. On October 19, 1951, Dr. Levin, who described himself as the clinic psychiatrist, wrote to Miss Muir's family physician. Marie Scorali, age 7. Despite this misidentification, there is no doubt that this letter refers to the patient. This child presents a very interesting problem which we would like to go into deeper, but we feel that a psychometric is at present all important. An appointment was made for her on October 13th, but she did not appear at the clinic. The evidence established that no psychometric testing was done on Miss Muir in 1951. Psychometric testing has been identified by Dr. J.T. Keegan, one of the trial witnesses, as a way of obtaining samples of human behavior that can be established as reliable and that can be replicated. In November 1952, the chief clinic psychologist of the Provincial Guidance Clinic at Calgary wrote to Dr. Levin asking for the Red Deer Clinic's file on Miss Muir. In this memorandum, Miss Muir was referred to as Moira Scorab. Again, despite the identification given, this memorandum definitely concerns Miss Muir. This memorandum states in part, "Our present information is that she is stealing from shops and from home, especially food. She is not reported as a school problem." Dr. Levin replied, not surprisingly, that he had no record of Moira Scorab. The Calgary Guidance Clinic wrote back it now identified the child's name as Leilani Scora, usually called Maud. Dr. Levin then replied as follows, quote, "From vague recollection of the case of Marie Scolari, I think a brief informal note-taking was taken on this child, but due to restriction of time, it was felt that it would be preferable if she came back the following week when a more formal history and psychometric could be administered. As you will note, she did not return, and we are sending you our file card and a letter to the doctor, which is all the history we have on this child," end quote. In February 1953, Ms. Scora filled out an application to the Provincial Training School for Mental Defectives in Red Deer, Alberta, asking them to admit Leilani Marie Scora to the institution. Although Ms. Scora filled out the application, she did so in the name of Harley G. Scora. She signed his name to the application. It is likely that the application was shown in Mr. Scora's name because Mr. Scora was a constable for the village of the Black Diamond, and that municipality had agreed to pay the costs of Miss Muir's detention at the school. This undertaking was subsequently revoked when Mr. Scora left that employ in 1953. No psychometric testing of Miss Muir was done in 1953. In February 1953, Dr. Levin wrote to Mr. Scora stating that Miss Muir's name would be placed on an urgent waiting list, and we will admit her as soon as we have a suitable vacancy. In November 1953, a psychiatrist attached to Holy Cross Hospital wrote to the Red Deer Guidance Clinic asking for information about Miss Muir. The request included this comment, "I understand that she has been seen and thoroughly studied in your clinic, and I would greatly appreciate a brief summary of your findings and conclusions." The Red Deer Clinic responded, quote, "It is our impression that the child is a mental defective, and an application form is on file for her admission to this school. However, we have no official certification of mental deficiency on file for this case," end quote. On July 12, 1955, Miss Muir was admitted to the Provincial Training School for Mental Defectives at Red Deer. The only application form relating to her admission was the 1953 form. It was not updated. The form anticipates that a physician was to witness the signature of the person giving information, thereby confirming the information set out in the application. No physician signed the form. The form anticipates that psychometric examination of the person to be admitted has been undertaken. No testing of Miss Muir had been done. On the application form, under the heading "Facts Indicating Mental Deficiency Observed by Myself," Dr. Levin indicated on July 16, 1955. 1. Appearance, pleasant-looking child. 2. Conversation, talks easily and volubly. 3. Psychometric examination, blank. 4. Other data, if any, bearing on cause or diagnosis. Ms. Skora, using Mr. Skora's name, signed the following form on the day that Miss Muir was admitted to the school. Quote, I am agreeable that sterilization be performed on my child, Lilani Marie Skora, if this is deemed advisable by the Provincial Eugenics Board, end quote. The evidence establishes that Miss Muir would not have been admitted to the school if one of her parents had not signed this form. The ward admission record of Miss Muir's admission states, mental condition, seems intelligent, moron. Deformities or abnormalities, third finger on both hands deformed. Scars and their location, a number of very small scars on body, 2 scars on right knee, 2 scars on left knee, scars under chin. Condition of clothing, rather shabby. On December 15, 1955, Dr. Levan wrote to the psychologist at the Provincial Guidance Clinic in Calgary to ask if psychometric was ever done on Miss Muir. On December 20th, 1955, that psychologist replied, quote, the above-named child was referred to the Provincial Guidance Clinic on November 5th, 1953. An appointment was made for November 1953, but the appointment was not kept. On November 27, 1953, the psychiatrist attached to the Holy Cross Hospital phoned to inquire about the child as the parents had told him they had been to the clinic. Dr. Hanley, the psychiatrist, had seen the child in consultation at the Holy Cross Hospital. He was not sure of the diagnosis but thought that there was an emotional involvement rather than a primary mental deficiency. The family had taken Marie to the Red Deer Guidance Clinic, but they were not seen as an appointment had not been made. On December 19, 1955, upon inquiring, Dr. Hanley's office informed us that there had been no further contact with this girl. To our knowledge, there has never been a psychometric given to this child, end quote. Despite receiving this information from the Calgary Guidance Clinic some 6 months after Miss Muir had been admitted to the Provincial Training School for Mental Defectives, Dr. Levan did not arrange for any follow-up to Dr. Hanley's report. There was no psychometric testing of Miss Muir. There was no investigation into the possible causes of emotional involvement. There were no other actions taken. Mr. and Mrs. Skora moved a lot. Some of these moves were within central Alberta, others were in Ontario and in Saskatchewan. Presumably, because of these moves, there were long periods of time where Mr. and Mrs. Skora had no contact with Miss Muir. In particular, there was little contact between Mr. and Mrs. Skora and Miss Muir immediately following Miss Muir's admission to PTS. In June 1956, an administrator at the school wrote Mr. and Mrs. Skora as follows. Quote, I am enclosing a letter from your daughter Lilani, who is a trainee at the school. It has been such a long time since Lilani heard from you that she has become most anxious and has not been able to do her best work at the school. She is beginning to feel you have forgotten her and that you won't be coming to see her. As I am sure this is not the case, would you please advise the medical superintendent when you will be coming to visit Lilani and when you will be having her home for the holidays this summer? End quote. Contact between Mr. and Mrs. Skora and Miss Muir improved after this communication. Indeed, while she was a trainee at the Provincial Training School, Miss Muir left the school from time to time to be with her family. These visits varied in length, from a weekend to a stay of several months' duration. In November 1956, Mrs. Skora wrote to Dr. Levan to explain why Lilani had not yet returned to the Provincial Training School. That letter contained the following comments. Quote, now Lilani has a black eye. I was sawing wood with Harley when I threw wood to the side of me and it struck her square in the face. She doesn't seem to understand to stay out of the way. Heaven only knows when she really will. I pray soon. End quote. On November 15, 1957, Miss Muir was finally given psychometric testing. She had begun to menstruate shortly before the test was administered. The test behavior portion of the psychological examination report indicates, quote, Lilani is pretty, but immature-looking child who sucked her thumb constantly throughout testing. The general findings were verbal IQ 70, borderline, performance IQ 64, defective, full-scale IQ 64, defective. The individual scores on the tests are not recorded. The following comment accompanied these results. The full-scale IQ of 64 places Lilani in the defective category. This level is considered accurate. Her top level of function would be only slightly higher. The examination report concludes with this paragraph. Analysis. Verbal abilities are slightly higher than those requiring visual motor coordination. There is comparatively little scatter on verbal scale. Her thinking is primarily concrete, although there is sporadic use of functional concepts. Her memory is fairly good. Her judgment tends to be poor. She is quite observant, her score on this subtest being within the average range. Social anticipations are weak. Visual motor skills are average for her level of ability. A clinical record, also called a progress diary, was kept of Miss Muir's experiences at the school. Although there are many references to her laziness and impudence, there are also remarks of the following type. January 1956. First note after admittance in July 1955. Lilani is doing very well at school. January 1957. Lilani has completed her work for Level 2 in reading and number work, and because of her reading ability to get new words, she is reading with others in Level 3, in friends and neighbors. Her number work is also up to the Level 3 standard. In November 1957, Miss Muir's case was brought to the attention of the Eugenics Board. The diagnosis made by Dr. Levin was mental defective, moron. Under the heading Personality, Social, Sex, there is the following entry. Lilani has shown a definitive interest in the opposite sex. Under the heading Present Condition, the report states, in part, quote, Lilani is young and needs considerably more training in self-control, good work habits, and personal care habits before it is possible to consider discharge for her, and even then she will be most likely to be placed in an environment where she will receive strict supervision, end quote. Under the heading Reason for Sterilization, this is the complete entry. Quote, danger of transmission to the progeny of mental deficiency or disability, also incapable of intelligent parenthood, end quote. The Eugenics Board of Alberta approved the sexual sterilization of Miss Muir on November 22, 1957. She was passed clear for a salpingectomy to be performed by one of a list of named surgeons. The term passed clear was used by the Eugenics Board to mean that no additional steps had to be performed. Obtaining consents or further psychometric testing before the actual sterilization could be done. The Provincial Training School for Mental Defectives was not proposing to discharge Miss Muir in 1957 when the psychometric testing preparatory to sterilization was done and the approval of the Eugenics Board for the sterilization was given, or in 1959 when the sterilization was actually performed. Indeed, when Miss Muir left the school in 1965, it was against the advice of medical staff. The clinic record or progress diary entries for 1958 and 1959 are as follows. January 1958. If she is in the mood, Lilani is a good little worker, but she usually requires a good deal of supervision to get there to accomplish anything. Lilani works well and is making good progress in Level 4. January 1959. Lilani is alert and making good progress in Level 5, but her working habits are rather untidy. She is usually well behaved in class. On January 18, 1959, the government sexually sterilized Miss Muir. A bilateral salpingectomy was performed by one of a list of named surgeons. A routine appendectomy was performed at the same time. Dr. Levin assisted with the surgery. A pathology report was done on Miss Muir's right and left fallopian tubes. The entire length of both of her fallopian tubes was removed. The extent of the operation resulted in Miss Muir's sterilization being completely irreversible. Her record contains no mention why both tubes were removed in entirety. Instead, only a small section was done in other cases. At the same time, an appendectomy was performed. On January 23, 1959, Miss Muir was discharged from the school's hospital. In July 1960, Dr. Levin wrote the following letter to the Superintendent of Child Welfare for Alberta. Quote, this child's parents are residing in Ontario at the present time. It would appear that they have abandoned this child and are not providing spending money or clothing which has been requested. Would there be any possibility of Lilani being made a government ward in order so that she might enjoy the same comforts that many of our other children do? End quote. When the Alberta Department contacted its counterpart in Ontario, it used the following language. Quote, the above-named child, an inmate of the Provincial Training School, has apparently been abandoned by her parents, end quote. After this exchange of correspondence took place, Mr. and Mrs. Skora did occasionally send spending money to Miss Muir. In 1963, a social worker saw Miss Muir in a home visit. She recorded her impressions as follows. Quote, I realize I don't have all the facts, but from what I have observed of the family, I wonder if the best interests of this girl are being served. I have had other occasions to deal with these people, and it appears to me that Mrs. Skora attempts to destroy the confidence of her children. End quote. In 1964, Dr. Levan asked a social worker to make an assessment of the Skora home situation. The social worker comes to the following conclusion. Quote, Leilani would like to live with her family, and I believe her father would like to have her, but his ill health makes him very dependent on his wife. Mrs. Skora was very definite that she didn't want Leilani. She emphasized the financial reasons, but I feel she has little affection for Leilani and just cannot face a future in which the supervision of Leilani would be permanent. End quote. Miss Muir's mother was alive when Miss Muir started this action, but died before the action came to trial. As noted earlier, Dr. Levan, who was the director of the provincial training school at the time in question, was a medical doctor, but not a psychiatrist. He died before the action came for trial. In 1950, he wrote an article for the American Journal of Mental Deficiency in which he made the following comments. Quote, indeed, the picture of comparison between the normal child and the idiot might almost be a comparison between two separate species. On the one hand, the graceful, intelligently curious, active young Homo sapiens, and on the other, the gross, retarded, animalistic, early primate-type individual. It is on this clinical basis that we find it difficult to associate schizophrenia as a regressive disease of the mind, if we may postulate a schizophrenic state in these idiot types. It is rather that the mind has acquired an archaic form of thinking, which in the adult is admixed with his cultural experiences and in the idiot shows itself uncomplicated and primitive with little distortion. We feel that this archaic type of thought is more extensive than has thus far been believed to be the case. End quote. In 1959, Dr. Levan wrote an article on the use of trifluoperazine as a tranquilizing agent in mentally defective children. In it, he makes the following comments. Quote, although substantial numbers of children have responded adequately to chlorpromazine, perfenazine, promazine, Respirine, or other atteractic drugs, there remain sufficient numbers who have not. Because of this, we continue to screen new compounds for possible use at the training school. A preliminary report describing the effects of trifluoperazine in 33 mentally defective children exhibiting behavioral disorders has already appeared. The present report describes the results obtained in 17 patients from the original study and an additional 25 children with behavioral and/or convulsant disorders. End quote. Mr. Kerr, a trial witness who worked at the PTS, describes Dr. Levan as a complex person. Mr. Kerr was surprised to hear the description Dr. Levan had made of the lower-grade mental defectives in the 1950 article. Mr. Kerr gave examples of what he considered to be Dr. Levan's caring attitude for inmates at the PTS, even if inmates were of the idiot classification. There is little evidence about the education levels and job placements achieved by Mr. and Mrs. Skora and Miss Muir's siblings. There is a suggestion in the evidence that Mrs. Skora at one time worked as a waitress and as a housekeeper, and that in 1962 she went for a 2-week auctioneering course in the United States, although it is not clear that she ever worked as an auctioneer. Mr. Skora worked as a farmer, as a police constable for a short time, and as a truck driver in the last few years before Miss Muir left the PTS. In one communication, Miss Skora indicates that one of her sons went to engineering school in Edmonton. However, there is nothing in the evidence to suggest that Miss Muir's home was one in which education and training were prized. One of Miss Muir's siblings is a laborer. During the whole time that Miss Muir was at the PTS, her family's finances were very bad. The family moved around a lot, and the health of her family seemed very poor. The evidence establishes that in the 1950s, foster homes and smaller group homes were available for the care of emotionally disturbed children. There were also opportunity classrooms in the schools of urban centers. These special classes were available for students who were not mental defectives, but who, because of emotional or other disturbance, could not follow the regular program. During the last 5 years of Miss Muir's confinement at the Provincial Training School for Mental Defectives, there was on the grounds of the PTS a program called Linden House. This program was for children who had been recognized as having emotional difficulties. These children were not branded as mental defectives. They received concentrated therapy, counseling, psychological support, and a carefully tailored educational program. Residents in Linden House were not detained under the Mental Defectives Act. They were not sterilized. After she left the PTS, Miss Muir began to live independently. She found and maintained employment. Over the years, she worked as a waitress, a retail clerk, a building manager, and a child daycare worker. She married not long after she left PTS, but quickly realized this was a mistake. The marriage lasted approximately 1 year and terminated in 1970. In 1978, she began a relationship with the man whom she married in 1980. Her husband knew that she could not have children. She and her husband applied to become adoptive parents. However, they were refused because of an unfound allegation of abuse against a child that she had been babysitting. After the refusal, her second marriage broke down. She acknowledges that her husband was an alcoholic and that he was having extramarital affairs. They separated in 1986 and divorced in May 1995. Miss Muir currently works part-time in a Bay cafeteria in Victoria. She is a member of a union and her hourly wage is approximately $10.68 an hour. Because of the type of work she does in this cafeteria, she would not be expected to earn tips. Miss Muir lives independently, attends church occasionally, gardens, plays bingo, and enjoys needlework and reading. In the first 15 years following her departure from the PTS, Miss Muir underwent many surgical and investigative procedures in order to determine what had been done to her and if it could be reversed. In July 1966, approximately 1 year after leaving the provincial training school, Miss Muir was hospitalized for a hysterosalpingogram, medically defined as an X-ray of the uterus and fallopian tubes after the injection of an opaque material. No fallopian tube could be seen beyond the outside wall of the uterus. In September 1971, Miss Muir consulted Dr. J.H. Dixon, a Victoria specialist in obstetrics and gynecology, to see if she could bear children. Dr. Dixon apparently advised her that an operation might be performed to move one of her ovaries closer to her uterus. In May 1974, Miss Muir underwent such an operation at the Victoria General Hospital, performed by Dr. J.G. Marr. Dr. Marr noted the previous surgical scar, which he reopened for the purpose of his operation. Inside Miss Muir, he found numerous adhesions which had to be surgically separated in order to see part of the uterus. At least one of these, attaching the bladder to the uterus, he attributed to her previous surgery. Following the operation, Dr. Marr entertained little hope for its success in reversing Miss Muir's sterilization. From 1971 to 1977, Dr. Faulkner was Miss Muir's family physician. In September 1975, Dr. Faulkner referred Miss Muir to a psychiatrist, Dr. E. M. McTavish, who wrote the following after his meeting with Miss Muir. Quote, "The problems Miss Muir complains of and wishes help for are pretty unhelpable. She complains that she has difficulty in accepting the fact that due to sterilization in her early teens, she is unable to have children. I pointed out to her that this was a fact and had to be accepted. Her unhappiness in regard to it is understandable and in no sense pathological. The damage done to her self-image and to her reproductive capacity cannot be undone." End quote. In March 1979, Miss Muir saw another Victoria specialist in obstetrics and gynecology, Dr. M. Rippington, who performed a laparoscopy, insertion of an instrument into the abdomen to allow visual examination of its contents, under general anesthetic. This required 2 incisions in Miss Muir's abdomen. Once again, adhesions were seen and attributed to the previous surgery. Dr. Rippington concluded it was highly unlikely anything could be done for Miss Muir. In late 1980, Miss Muir sought the opinion of a third Victoria specialist in obstetrics and gynecology, Dr. E. Prevost, who in turn consulted a Vancouver specialist, Dr. V. Gomel. After reviewing the operative notes of Dr. Marr and Dr. Rippington, he concluded further reconstructive efforts would be futile. Following the receipt of Dr. Gomel's opinion, Miss Muir accepted Dr. Prevost's recommendation for a hysterectomy, which was performed in February 1981. In its course, numerous internal adhesions were noted, as well as surgical scars on the lower abdomen. Following her hysterectomy, Miss Muir discussed with her family doctor the possibility of a test tube pregnancy. In her words, "I would have tried anything." Miss Muir and her second husband also sought to adopt a child but were unable to do so, according to Miss Muir, because of an unfounded allegation that they had mistreated a child for whom Miss Muir was providing daycare. B. Law. Sexual sterilization legislation. Section 4.1 of the Sterilization Act empowered a medical superintendent of a mental hospital to cause a patient of a mental hospital whom it is proposed to discharge therefrom to be examined by or in the presence of the board, with a view to sterilization. Section 6 of the Sterilization Act established 2 grounds for sterilization, namely that procreation by the person under consideration, A, would result in the transmission of any mental disability or deficiency to his progeny, or B, involved the risk of mental injury either to such person or his progeny. The original Sterilization Act established a board, whose members were named in the legislation to carry out its terms. Some months later, a second board was established by order in council. This board's function was to gather and disseminate information on eugenics pursuant to the Department of Public Health. The second board was named the Eugenics Board for the province of Alberta. Its members were, at the time of its inception, the persons named to the board created under the Sexual Sterilization Act. By the time of Miss Muir's sterilization, 3 of the 4 original members of the board had been replaced. Orders in council appointing 2 of these 3 members show that the members held an appointment to the Eugenics Board established pursuant to the Sexual Sterilization Act. In 1960, the entire board was reconstituted by order in council. That order in council established for the first time a eugenics board pursuant to the Sexual Sterilization Act and reappointed the members who had sat on the old board to the new entity. Legislation for the confinement of mental defectives. Section 5.1 of the Mental Defectives Act, under the heading Procedure Respecting Admission, provided that, quote, a person who desires to have a mentally defective person who is under his charge or control, placed in an institution established for the purpose under this act, shall make application to the superintendent, and if after due investigation and upon receipt of the prescribed forms properly completed, the application is approved by the superintendent, the mentally defective person may be admitted by the superintendent of the institution. Overview on the law of damages. This is a tort action. It must be distinguished, for example, from an action in contract. Before damages can be awarded, the court must find that a wrong has been done. The overriding objective in awarding damages in such a lawsuit is to compensate the injured person, not to punish the wrongdoer. The objective of the court is to give the plaintiff financial compensation for the damage, loss, or injury that she suffered. A court can compensate for financial losses suffered, such as the loss of income or expenses of medical treatment or expenses to repair a car. A court can also compensate for other types of losses, such as physical pain and injury to feelings. The calculation of the latter kind of damage is difficult. Money is awarded not as a direct compensation for what has been lost, but as an attempt to provide what money can do, make the real loss somewhat easier to bear. Sometimes the wrongful action has, nevertheless, had some beneficial effects on the victim. Credit must be given to the wrongdoer for any savings, for example, that the victim has achieved despite the wrongful action of the defendant. The court has the power to award damages under 3 headings: pain and suffering, aggravated damages, and punitive damages. Pain and suffering. Damages for pain and suffering cannot be tested by any objective standard. They are awarded by the court on the basis of its opinion and judgment of the amount of money that can comfort the plaintiff for the damage which she has proved. Suffering includes, for example, fear of incapacity, fear of being unable to earn a living, humiliation, sadness, embarrassment, social discredit, and loss of freedom. Aggravated damages. The best way to describe aggravated damages is to repeat what other courts have said about them. Aggravated damages are given to compensate the plaintiff when the harm done to her by a wrongful act was aggravated by the manner in which the act was done. Aggravated damages may be awarded in circumstances where the defendant's conduct has been particularly high-handed or oppressive, thereby increasing the plaintiff's humiliation and anxiety. These damages take into account the additional harm caused to the plaintiff's feelings by the defendant's outrageous and malicious conduct. Like damages for pain and suffering, they are compensatory in nature. Punitive damages. This category of damages is not awarded to compensate the victim. Rather, the damages are awarded to punish a wrongdoer where the wrongdoer has not been punished in any other way, for example, by being convicted of a criminal offense. A noted academic writer, Salmond, who specializes in tort law, distinguishes between the last two categories of damages in this way. Aggravated damages are given for conduct that shocks the plaintiff. Exemplary or punitive damages for conduct which shocks the jury. These are other explanations given to distinguish punitive from aggravated damages. Exemplary damages, that is, punitive damages, are intended to punish the defendant and presumably to serve one or more of the objects of punishment, moral retribution, or deterrence. Punitive damages may be awarded in situations where the defendant's conduct is so malicious, oppressive, and high-handed that it offends the court's sense of decency. Punitive damages bear no relation to what the plaintiff should receive by way of compensation. Their aim is not to compensate the plaintiff, but rather to punish the defendant. But for punitive damages, it would be all too easy for the large, wealthy, and powerful to persist in injuring vulnerable victims. Procedure. Because the events on which this lawsuit depends happened such a long time ago, the parties entered into an agreement about the use of documents at trial. The document is what it purports to be, with the single exception of the document numbered A013, the sterilization consent signed by Harley Scora on July 12, 1955. Where the document bears a signature, that signature is the signature of the party who purported to sign it, again with that exception. The documents are in the same condition at the time of trial as they were when the document was generated. In the case of letters, they were written by the signatory, were sent, and were received by the party named as the recipient, with the exception of some letters that were not provided to the recipient. The documents speak for themselves but are open to interpretation by each of the parties as to their legal and factual significance. The documents are subject to whatever objection as to relevance that may be made by either of the parties, having regard to the admissions that have been made. This agreement between the parties reflects law and common sense. The documents were prepared contemporaneously with the events, well before the possibility of any legal action was considered. The documents are usually the best record of what transpired. In a few circumstances, the documents are suspect. Those situations will be described more fully in the reasons. Although the defendant has tried to put all relevant documentation before the court, it has been established that some of the provincial training school documents stored in the sub-basement of the Missioner Center were destroyed in a flood. Part 2. Witnesses. The court makes the following assessment of the major witnesses. A. Miss L. Muir. Miss Muir is not a reliable witness about the events of her childhood. This is demonstrated, among other evidence, by the school attendance record, which shows that, at least during one period of time during her early childhood, Miss Muir attended school regularly, rather than sporadically, as she recalls. The evidence that suggests that she was at the Midnapore Convent for a much shorter period of time than she now recalls. More importantly, Miss Muir is not a reliable witness about events that occurred not long before she left provincial training school. This is mainly demonstrated by the characterization as bogus by Miss Muir of letters that she obviously wrote. The evidence of the handwriting expert Peace, whose evidence I accepted, concludes that certain letters were written by Miss Muir, even though Miss Muir does not now recall having written them. He also establishes that it was Miss Scora, not Mr. Scora, who filled out the application form for the PTS and who wrote to Dr. Leven. In addition, Miss Muir's recollection of her employment since she left the provincial training school and of her application for Canada Pension Plan benefits is not accurate. Therefore, Miss Muir's evidence about events in her childhood and beyond will usually only be relied on if there is independent evidence that substantially supports her testimony. There is independent evidence to support the following conclusions. Miss Muir had an abnormal number of scratches when she was admitted to the institution. Miss Muir had a very bad relationship with her mother. Miss Muir was denied food when she was with her family. Miss Muir was sterilized. Miss Muir's appendix was removed. While at PTS, Miss Muir was disciplined in a harsh and inappropriate way. While at PTS, Miss Muir was essentially confined. While at PTS, Miss Muir was dealt with as if she were a mental defective. Miss Muir was at no greater risk of having mentally defective children than anyone else in society. Nothing in the evidence suggests that Miss Muir was incapable of intelligent parenthood. However, there is no independent evidence to establish that Miss Muir's mother bent her fingers back as a means of discipline. On the contrary, documents establish that this was probably a genetic malformation. The above conclusions are not exhaustive, but illustrative of the manner in which the court approaches Miss Muir's evidence. The government argues that an adverse inference should be drawn against Miss Muir's position with respect to her pre-provincial training school treatment, because Miss Muir did not call her brothers to testify. Given the young age of her brothers when she herself was a child, it is not surprising she did not call them as witnesses. We could not expect them to add anything reliable to the evidence given by Miss Muir about her life at home up to the age of 10. The government also suggests that an adverse inference should be drawn against Miss Muir's position because she did not call the physicians who have treated her, including Drs. Faulkner, Zadel, Bailey, and Kernable, and her psychiatrists, Drs. McTavish and Kovich, to give evidence. However, the defendant had received documents prepared by each of these physicians. Drawing an adverse inference of this type is not called for. An adverse inference should only be drawn where the court is satisfied that the plaintiff did not call the potential witnesses because those witnesses were likely to give evidence that was not favorable to the plaintiff. Here, Miss Muir was seen by several psychiatrists who did testify. In addition, we have documentary evidence from Miss Muir's physicians about Miss Muir's condition over the years. There is no reason to suggest that if these additional physicians had been called to give evidence, they would have developed a different picture of Miss Muir. For example, the defendant suggests that Dr. Kemble told Dr. Zadel in June 1992 that Miss Muir denied being under any stress. However, despite Miss Muir's representation to him, Dr. Kemble concluded that Miss Muir was under stress. At trial, Miss Muir's testimony is that she is always under stress. If Miss Muir had gone to the trouble and expense of calling Dr. Kemble, he would only have supported her own assertion that she was always under stress even when she denied it. So there was no point in calling Dr. Kemble. No adverse inference should be made against Miss Muir for not having called him. The same approach applies to each of the other physicians who did not testify. Finally, the government suggests that an adverse inference should be drawn against the evidence of Dr. Calder, because the person who administered the test, now Dr. Lyons, was not called as a witness. I decline to draw this inference. Dr. Calder is responsible for the test results administered by another person, just as Dr. Keegan, the government witness, is responsible for the test results administered by persons on his staff. There's no need to call the person who administered the Calder tests. In summary, although no adverse inferences are drawn against her because of her failure to call additional witnesses, Miss Muir's evidence is treated cautiously by the court unless that evidence is confirmed by other sources. B. Dr. P.E. Corpus. Dr. Corpus is a psychiatrist who examined Miss Muir for the purpose of these proceedings. He testifies as a medical legal expert, not as a treating physician. I accept his opinions about the level of psychiatric knowledge about mental defectives that should have been known in Alberta in 1955 to 1959. 4 main reasons lead me to this conclusion. First, Dr. Corpus testified that he made special efforts to place himself in the position of a psychiatrist at that time and in that place. He made this effort by recalling his own years of training and by reviewing texts from the period. I note that his personal education, training, and experience are similar to those of Dr. Brown and Dr. Levan. Second, his evidence is fully supported by the evidence of the guidance clinics operating in Alberta at the material times. Those clinics had psychologists, psychiatrists, and social workers attached to them. It is obvious that it was understood in Alberta in 1955 to 59 that it would be necessary, in dealing with some mental defectives, to use the services of psychologists and social workers in order to obtain background information. His evidence is also supported by the forms that were used at the PTS during the time in question. The forms recognized that family background information was important to the determination of mental defect. Third, the Eugenics Board itself recorded, especially in the early years of its operations, that some children were developmentally retarded but did not come within the board's mandate because they were not mental defectives. The board was therefore well aware that it was necessary to distinguish between mental defect and emotional involvement as the root cause of development delay. Finally, the opinion of Dr. Hanley, a specialist psychiatrist practicing in Alberta, and even more particularly in the province's guidance clinics in 1953 and 1955, conclusively establishes that it was known in Alberta that emotional problems could cause developmental delays. I also accept Dr. Corpus's testimony about the effect of sterilization on Miss Muir's life. Dr. Corpus discussed the breakdown that Miss Muir suffered after the breakup of her second marriage, and Miss Muir's sterilization in this way. Quote, her breakdown at the time would also have coincided with the middle-age stage of her life cycle, when issues of childbearing become very prominent for some women. Although childlessness can become a significant traumatic psychological factor for women who are passing through midlife, for Miss Muir, the issue of sterilization had almost certainly affected her life from the time of her early 20s when she first confirmed her condition. The impact of this discovery on a young woman attempting to build her self-esteem and an image of herself as an independent, competent adult would be hard to overestimate." End quote. Finally, I accept Dr. Corpus's evidence about the effects of institutionalization. Dr. Corpus has not made a specialty of institutionalization. However, as a psychiatrist with a broad practice, his opinion about the impact of institutionalization on individuals is based on his training and experience as a whole. His evidence about institutionalization is balanced. He acknowledges that there are sometimes benefits to institutionalization. He names these in Miss Muir's case as some security and some protection. I accept his evidence that the bad effects of institutionalization are regimentation and the lack of opportunity for forming attachments. In this case, those bad effects provided Miss Muir with only a limited opportunity for self-expression and testing of rules and the denial of normal opportunities for forming attachments and learning the skills of intimate relationships. Some institutionalized persons may have difficulty outside in forming close relationships. This happened to Miss Muir. See Dr. J.F. Keegan. Dr. Keegan is a clinical neuropsychologist whose specialty is administering psychometric tests. His evidence has established his great expertise in this area. Indeed, his expertise is so great that I think likely that his personal professional standards exceeded those of the average practitioner in his field. I accept, as indeed does Dr. Calder, Dr. Keegan's criticism of the testing done by Mr. Lyons, now Dr. Lyons. Indeed, I accept Dr. Keegan's testimony about the interpretation to be given to psychometric tests. When his evidence conflicts with that of Dr. Calder on the interpretation of tests, in particular with respect to the fact that verbal IQ is a better predictor of academic success than performance IQ, I prefer Dr. Keegan's evidence. However, Dr. Keegan did not actually test Miss Muir. Indeed, he never met her. His evidence successfully challenges the original results proposed by Dr. Calder. Dr. Calder accepted the criticisms made by Dr. Keegan and corrected the scores. To some extent, Dr. Keegan disagrees with Dr. Calder on the interpretation of the tests. These differences should not be exaggerated. As Dr. Calder points out, his final results and those of Mr. Kurbatoff, which Dr. Keegan accepts, are very similar. Dr. Keegan readily acknowledges that he does not specialize in assessing the effects of institutionalization on individuals. Therefore, where his opinion conflicts with Dr. Corpus on the issue, I prefer Dr. Corpus's opinion. D. Dr. P. Calder. Dr. Calder is a psychologist who administers tests and who also relies on clinical assessments. In this case, the tests that were administered for him by Mr., now Dr. Lyons. At the time he administered the tests, Mr. Lyons was a chartered psychologist and a doctoral student. The tests were administered more to confirm a clinical assessment than to create an assessment. Because Dr. Calder's interaction with Miss Muir was intended as the basis of making a clinical assessment, where his clinical assessment of Miss Muir disagrees with the opinion of Dr. Keegan based on the tests, I prefer Dr. Calder's clinical opinion. In fact, it would be more correct to say that Dr. Keegan did not form a clinical opinion, so there is on that point no conflict between himself and Dr. Calder. Dr. Calder's clinical opinion is that Miss Muir was sharp and that she did not appear to be a mental defective. Dr. Calder engagingly describes his need to temper his positive reaction to Miss Muir his feeling that she deserves a Nobel Peace Prize for overcoming the harshness of her early environment. I conclude that there is some practice effect that applied to improve Miss Muir's scoring on the performance test administered by Dr. Calder in comparison with the tests administered by Mr. Kubertoff. Although there were at least 8 months between the tests, and the literature speaks of practice effect occurring when the retest occurs within 3 months, even Dr. Calder says that he would not normally administer psychometric tests more frequently than once a year. The length of time between the tests and the similarities in the tests admits the possibility, posited by Dr. Keegan, that Miss Muir's improved performance is at least partially attributable to practice effect. E. Dr. G.A. Little. Dr. Little is an educational psychologist. The main part of her evidence, which I accept, is that the verbal score in IQ tests, rather than the performance score on those tests, is the best predictor of academic achievement. In this context, she notes that when assessing high school programs, there is a substantial difference between a vocational program and an academic program. In particular reference to Miss Muir's situation, Dr. Little testified that although Miss Muir had scored well on the picture completion test, this is not a skill which contributes very much to academic strength. One of the important issues discussed by Dr. Little, which I also accept, is that it is not right to think of a student who has missed many years of primary training as subsequently catching up. She explained that students like Miss Muir, who missed those early grades, fail to learn the basic skills on which they would draw during the remainder of their scholastic career. F. Professor G. Robertson. Professor Robertson provided background information on the eugenics movement and the effect of this movement had on legislation in Alberta. His background as an academic with special interest in matters of public policy affecting health gives authority to the material he has collected. Professor Robertson also undertook a study of the records of the operation of the Eugenics Board in Alberta. Even though Professor Robertson clearly favors recognition of the reproductive dignity of individuals with any kind of mental disability, I have concluded that those views have not interfered with his ability to review the Eugenics Board files in a statistically meaningful way and to provide the court with reliable information about the operations of the board in this province. I accept Professor Robertson's evidence about the operation of the Eugenics Board. In addition to the documentary support for his conclusions, Professor Robertson's assessment of the operations of the board is largely corroborated by the evidence of Dr. M. Thompson, a former board member and geneticist. Her evidence establishes that the powers of the board were used not in accordance with either scientific principles or legislative standards, but in support of social policy about who should be allowed to have children in Alberta. Her evidence also establishes that most requests for sterilization that came before the board, the inmate would never be discharged, or it would be a very long time in the future before any discharge were contemplated. Professor Robertson's evidence establishes that, routinely from the 1930s on, the board frequently dealt with cases at the rate of 10 minutes per case or less. The members of the board had no information on the cases in advance of their meetings. This speed of dealing with irreversible decisions establishes that the board could not have taken the time to examine the cases in any meaningful way. It is obvious that the board relied almost entirely on the recommendation of the executive director of the institution, Dr. Levan. Professor Robertson's evidence about the operations of the board is also largely confirmed and corroborated by the 1969 Blair Commission on Mental Health in Alberta. For example, Professor Robertson concluded that there were systemic biases in the operation of the board, so that, for example, females more than males, and females from Eastern Europe and Catholics and later female natives were more likely to be sterilized. This conclusion is supported by the Blair Commission's conclusion. Quote, further, the sterilization of individuals with depressed IQ ratings attributable to emotional or delinquency or subcultural factors, which are capable of some degree of amelioration, is open to debate, end quote. His conclusion is also supported by other materials referred to in his opinion. It is obvious that much of the early eugenics movement in Canada was based on a concern by those of British stock about the potential weakening of the race by immigrants. Many early Canadian socialists, such as J.S. Woodsworth, authors of Strangers Within Our Gates, and, when he moved to Manitoba, founder of the CCF, which subsequently became the NDP, were much in favor of maintaining racial purity in Canada by eugenic interference with the reproduction of East Europeans. Tommy Douglas originally espoused eugenic philosophy. Probably frightened by what he saw in Germany in 1936, he later turned away from eugenics. In 1944, to his great credit as Saskatchewan's Minister of Health, he firmly rejected 2 reports recommending the sterilization of the feeble-minded. In Alberta also, there was great concern in some quarters about the potential negative effects of immigration. This is one of the grounds on which 3 of the famous 5, Emily Murphy, Miss O.O. Edwards, and Miss Elsie McKinney, approved the sexual sterilization legislation, which was, sadly, to have negative effects on so many women. The immigration concern, which resulted in a systemic bias against those men and women from subcultural backgrounds, is a factor in this case. Miss Skora was born in Poland and was Roman Catholic. Miss Kerr's evidence also supports Professor Robertson's opinions. He testified that one of the things that the caregivers were told when a child was admitted was what religion the child was. Also, on the issues of the difference in the treatment of males and females, Mr. Kerr testified that at Linden House, the model school on the PTS grounds where the best of the government's resources were concentrated, boys outnumbered girls 5-1. Professor Robertson's report also establishes that while there was considerable support in Alberta in 1928 for government-sponsored sexual sterilization, even then support was not unanimous. In March 1928, for example, a Liberal politician asked what would happen if anyone suffered physical impairment as a result of sterilization, and if the board would be liable for damages or prosecution as a result of its decisions. Mr. G.N. Kurbatoff. Mr. Kurbatoff is a clinical psychologist. Approximately 8.5 months before Miss Muir was tested by Dr. Calder, Mr. Kurbatoff was asked to give an opinion to other health professionals at a Western mental health center about whether Miss Muir could profit from talking therapy rather than medication. Mr. Kurbatoff reports that Miss Muir did not appear to him to be mentally defective, that she did appear to be at the lower end of the normative range. That is, an opinion shared by all other witnesses and amply confirmed. Mr. Kurbatoff acknowledges that he was doing an in-house testing, but he maintains that he followed professional standards in doing so. This is confirmed by other evidence, including the evidence of Dr. Keegan. Mr. Kurbatoff also adds one point, which is important to note in this case. The normal range starts at 70. The defective range starts at 69. Dr. R.I. Brown. Dr. Brown, a psychologist and emeritus professor of educational psychology at the University of Calgary, has had much experience with persons who have been sexually sterilized. I accept his opinion that such a procedure had profound detrimental effects on their education and social and physical well-being. I also accept his opinion that it was detrimental to Miss Muir's overall well-being to be removed from school at age 17. She might have profited from extended education and training. Although Dr. Brown acknowledges that some of the work of Clark and Clark on the development of intelligence was only published in 1955, and that it takes some time for publications in learned journals to become the standard in everyday practice, one notes that Dr. Levan obviously thought of the PTS as being in the vanguard of training schools for mental defectives. Dr. Levan himself published in learned journals. More than another professional in this field, therefore, he might have been expected to be current with major developments in his field. He held himself out to be a superior psychiatrist. He has to be judged by those standards. Because of his vast experience in the field, I accept Dr. Brown's evidence that issues of choice and value are particularly important for people who have been institutionalized. Dr. Brown suggests that drugs may have had an impact on Miss Muir's school performance. I accept that evidence. I accept Dr. Brown's evidence that some women are adequate mothers even if they perform average on IQ tests. I accept that evidence. Finally, I accept Dr. Brown's evidence that in 1955, a proper assessment to determine if a child was mentally defective would have involved a multidisciplinary approach, including a clinical interview with parental involvement to obtain personal and family history, a medical examination to review the general health of the child, any physical damage or scars, rickets, infectious disease, lice, signs of mental handicap such as concrete versus abstract language, narrow range of vocabulary, stuttering, short attention span, hyperactivity, stability, dull face, epilepsy, physical deformities, IQ tests, records of academic achievement, a comprehensive social work report, including a home visit to ascertain the child's living conditions, including areas of potential neglect, dress, cleanliness, language, family stability, alcoholism, numbers, ages, and conditions of siblings, signs of abuse, and more intensive follow-up if any concerns arose during the initial assessment. His evidence on all of these issues is not only soundly based in his training, education, and experience, but it is corroborated by the very availability at the PTS of a social worker and a psychologist, and by the use by PTS of forms that require this type of information. I, Dr. M. W. Thompson. Dr. Thompson is a geneticist. She was also a member of the Eugenics Board from 1960 to August 31st, 1963. She had been given a leave of absence from September 1st, 1962 to August 31st, 1963. Her evidence conclusively establishes that the Eugenics Board did not meet the standards imposed on it by legislation. She acknowledges that the board could not, in Miss Muir's case or in many other cases, be certain that any defect of the trainee would be passed on to the trainee's offspring. Dr. Thompson testified that the board unilaterally modified the standard passed by the legislature of Alberta. In her opinion, the legislature had set a high standard that was unreasonably tough but too high to meet. Two illustrations fairly represent Dr. Thompson's approach to the sterilization determinations. Dr. Thompson was a member of the board that approved the sterilization of a boy who had a tested IQ of 76. Persons with an IQ of 70 or more were considered to be of normal intelligence. This particular boy's level of IQ rating was achieved despite a severe hearing defect. Being deaf could be assured to have had a negative impact on the education that he would have required to have done well on the verbal IQ testing. The PTS report commented that this boy had no interest in the opposite sex, but that he masturbated. The report added that he required little supervision in social hygiene. It was said that he was a poor worker. Dr. Thompson was asked why she approved the sterilization of this boy. She replied that social success is a factor to be taken into account in a sterilization decision. When the school reported that he was a poor worker, she concluded that despite all the information that he was a nice, quiet boy, he was not really functioning in society. She said that she was being protective of him when she decided to have him sterilized. Dr. Thompson was asked why she approved the sterilization of a male Mongol child when it had been known for decades that male Mongols were unlikely to reproduce. She replied that there was nothing lost by sterilizing the male Mongol. She thought everyone would agree with her approach. She thought that sterilization would make assurances doubly sure. Dr. Thompson's approach to the issue of who should be sterilized and why the legislation could be ignored is representative of the way in which the board operated. Even Dr. C.M. Hinks, medical director of the Canadian National Committee on Mental Hygiene, the single most active group favoring government sterilization, made the following comments to the Canadian Civil Council on Child Welfare, held in Vancouver, May 23, 1927. Quote, "Is sterilization of the worst cases of mental deficiency to be recommended? It must be admitted that there is no unanimity of scientific opinion in this regard. A certain group of scientists are opposed because they insist that our knowledge of heredity is all too scanty and that we cannot predict with precision the result of any given mating. I find myself favoring sterilization, not on eugenical grounds alone, but on unethical as well. I have been struck by the fact that the feeble-minded mothers are notoriously incapable of bringing up their children, and I am convinced that they should not be given an opportunity to thwart and stifle heavy child development. Sterilization would prevent them from having the responsibility of childcare." End quote. Dr. Thompson testified that eugenics was not primarily a scientific movement, but a political and social one. She believes that eugenics represented good social policy before the advent of easy contraception and before abortions were legal. She testified that just as only 2 to 4% of abortions are done for genetic reasons, and the rest are done for social reasons, so too was sterilization done essentially for social reasons. I do not accept Dr. Thompson's assertion that most people in Alberta supported the sexual sterilization program and that only Catholics opposed it. The Alberta Conservative leader in 1928, A.A. McGilvery, who was not a Roman Catholic, opposed the legislation in the strongest terms. Quote, "If you pass this bill, you are taking a serious and important step. It seems to me that this measure does not surround us with the protection we should have before we take a step of such moment to any living person." end quote. The Edmonton Journal of February 24, 1928, summarized his arguments in this way. Quote, any set of doctors who were not experts in their line, he argued, might call a man sane or insane when the reverse might be the case. Any board upon which it was intended to confer the tremendous powers proposed by this act must have outstanding psychiatrists in its membership. Before embarking on any such step as proposed in this bill, it should be referred to committee of the whole House, and the best medical men in the whole country should be called before the committee to give information and suggestions, end quote. In summary on this aspect of the evidence, although we must not assess the situation of the Provincial Training School for Mental Defectives through 1996 Eisen knowledge, it is also fair to report that even in the early days of the push for government sterilization in Canada, it was recognized that there was no solid scientific basis for the adoption of the program. I do not accept Dr. Thompson's evidence that any interest of the trainee in trainees of the opposite sex was not a factor that was taken into account in determining if sterilization was to be performed. It is disingenuous of her to advance that opinion. Information about interest in the opposite sex was a component of the limited information provided to members of the board. Dr. Thompson never arranged for the removal of that information. It seems clear from her evidence that persons who were brought before her were unlikely to be discharged. One can only conclude, therefore, that the sterilization was done primarily to control sexual activity in the institution, rather than for any of the purposes set out in the legislation. As early as 1932, we find the following letter written by the Commissioner of Mental Institutions in this province to the medical superintendent of the Brandon Medical Hospital. Quote, with respect to mentally defective girls, it is important to remember that, while one may take chances with a girl released from strict supervision, she still does require supervision if there are sex propensities. It is, I think, correct to say, however, that the ones we have had trouble with in this respect have shown very marked tendencies to sexual delinquency before operation, but undoubtedly supervision of a general character after the operation and discharge is advisable, end quote. Only months after Dr. Thompson ceased to be a member of the eugenics board, one notes a letter from a surgeon with a long association of performing sterilizations at the board's instructions, written in November 1963 to a member of the eugenics board. Quote, in an age where it is considered wise to render the female permanently infertile, then removal of a portion at least 1.5 inches of the conal end of each tube, or better still the whole of each tube, is completely satisfactory. This allows for the continuation of normal menses. Where it is considered wise to render the female permanently infertile and as well cause a cessation of the menses, one of two procedures may be carried out. That is, hysterectomy or bilateral oophorectomy with salpingectomy. In the adult bilateral oophorectomy with salpingectomy, it is relatively quick, easy, and effective, with but little risk. It also dampens the sexual urge and in some cases may be of value. In the child and adolescent, however, bilateral oophorectomy with salpingectomy causes a euconoid development. On the other hand, hysterectomy alone results in permanent infertility and absence of menses, but retains an ovarian function which is desirable, end quote. From the beginning to end of its operations, concerns about sexual tendencies of the inmates of the PTS were at the forefront of the administrator's attentions. I do not accept Dr. Thompson's evidence concerning the discussions she had with Dr. Levan regarding the taking of testicular tissue from vasectomized or castrated trainees. Both she and Dr. Levan were conducting studies of male Mongols, males with Down syndrome. She gave Dr. Levan detailed instructions about how to take samples of the tissue that resulted from the sterilization. In all the circumstances, this constituted encouragement to Dr. Levan to use the trainees as medical guinea pigs. This is all the more repugnant because from the 1940s on, Dr. Thompson and the board knew, as did all those involved in genetics, that male Mongols are infertile. Their sterilization was unnecessary. Dr. Thompson's evidence demonstrates that the operations of the board, initiated on a purported scientific rationale, degenerated into unscientific practices. The decisions of the board were not made according to the standards imposed on them by the legislation, but because the members of the board, like Dr. Thompson, thought it was socially appropriate to control reproduction of these people. I do not accept Dr. Thompson's evidence that care was taken by the board in deciding the fate of each individual trainee brought before it. Irreversible decisions were obviously made on the flimsiest of evidence. without any true scientific investigation of the eugenics situation of each trainee. Dr. Thompson testified that most of the people who came before the board could not read, write, or count, and could not dress or feed themselves. The board's and the school's own records amply refute such assertions. Minimal investigation would have disclosed the abilities of the trainees who were presented for sterilization. Finally, it is interesting to note that although the board did not authorize appendectomies, Dr. Thompson never questioned the reports that almost always noted that an appendectomy had been performed at the same time as a sterilization. 3. Damages for sterilization. The government acknowledges that it must pay Miss Muir damages for the sterilization. The government states that this liability arises because, in this particular case, adequate testing was not undertaken before the decision was made to permanently sterilize Miss Muir. The admission is only with respect to this case and is made only because the inadequate testing preceded an irreversible medical decision. 2 overall factors apply to each aspect of the award of damages for Miss Muir's sterilization. A. Individual award. This is an individual award based on the evidence in this case. Some women and some men seek out and welcome sterilization. For some women and some men, the fact of sterilization may be neutral or only of mild concern. Therefore, the award in this case does not necessarily provide a guide for other cases of sterilization or forced sterilization. B. Is 1959 or 1996 the right standard by which to award damages? The time of judgment is the appropriate time to use as the gauge to set damages. In other words, although the sterilization occurred in 1959, the court should award damages according to the 1996 standards for damages. The parties have agreed that this is so, and Alberta case law supports this position. There are 2 components to the issue about what is the right temporal standard for the award of damages. 1, the simplest of the 2, is the present value of money. When the court uses the date of judgment as the date for damages, it is ensuring that the damages award keeps pace with inflation. So, if Miss Muir had sued the government in 1959 and the government had admitted its liability to pay her damages in 1959, and the court had awarded damages in 1959, but somehow that award had not been paid, the court must ensure that, in 1996, the government should pay an amount that is the $1996 equivalent of the 1959 award. The courts have evolved 2 ways of ensuring that a judgment reflects current dollar values. It can award prejudgment interest, or it can use a calculation that takes inflation into account. In this case, the damages for sterilization are awarded on the basis of a predetermined calculation which considers inflation. The second component of counsel's argument about the correct temporal standard for awarding damages is the determination that it is today's approach to awarding damages, not the standards of 1959, that applies. Perhaps in 1959, once the government had admitted its obligation to pay damages, the court would have awarded only nominal damages, whereas courts in 1996 would not award merely nominal damages. If this approach were used, the nominal award would be slightly grossed up to $1996, but the base would still be a nominal one. The parties agree that the 1959 approach to damages is not the correct one. With respect to the views of counsel for both parties, I note that the case on which they rely, Adam and Hatton, for example, deal only with the first facet of the issue of the temporal standard for the award of damages, the need to take inflation into account. None of the case law cited deals with a situation such as the one we have here, where the wrongdoing occurred such a long time ago that there might have been a completely different juridical approach to the quantification of damages for torts of this type. It may be, for example, that in 1959 there was no developed principle about the award of punitive damages and that such damages could not be said to be routinely part of the common law. Nevertheless, I have decided to adopt the position urged by both parties. I do so for the following reasons. First, one of the features of the law of damages for tort that changed between 1959 and 1996 is the cap or upper limit of $100,000, adjusted since then for inflation, imposed by the Supreme Court of Canada on damages for pain and suffering in 1978 in the cases of Andrews, Thornton, and Arnold. Prior to 1978, there was no such cap. Therefore, in 1959, it might be just as possible that an award of damages for pain and suffering higher than the current $100,000 ceiling might have been imposed. In other words, the solution adopted by the parties recognizes that the adoption of the 1996 temporal standard is not unfair to the government, since the government bears the risk that there was no ceiling to awards for pain and suffering in 1959. The second reason that I adopt the temporal proposal made by the parties for assessing damages is that, to the extent this might be seen as magnanimous on the part of the government, the court can take this conduct into account in determining whether punitive damages should be awarded. Pain and suffering. Miss Muir has suffered throughout her adult life as a result of the forced sterilization. Her pattern of conduct, summarized in the background section of these reasons, in consulting physician after physician during a 15-year search for physical and psychological relief from the sterilization, during a period where there was no thought of a lawsuit for the sterilization, solidly supports Miss Muir's testimony about the effect of her sterilization. The testimony of Dr. Corpus and the judicial notice taken by the SCC in the case of Re-Eve about the importance to human beings of the potential for conception established that, objectively, it is in human nature to be profoundly concerned about sterilization. In this case, based on the evidence I have heard and accepted, I am satisfied that the sterilization had a catastrophic impact on Miss Muir. It changed, warped, and haunted her life. Money will not allow Miss Muir to conceive. It can only provide some succor for the pain she has suffered during these past decades. She is entitled to the maximum amount of damages that the law allows for pain and suffering. That amount, as of September 1995, was $250,280. Counsel will update the amount to the date of the issuance of these reasons. Why does the court choose the maximum damages that could be awarded for pain and suffering? The first reason is one given above, which is that the injury had catastrophic effects and therefore the award for catastrophic damages is appropriate here. The second reason is that the maximum award is consistent with the other awards that have been made by other courts for similar damages. In Antonopolis, the SCC confirmed an award of $250,000 to a woman who, at the age of 22, was in a serious motor vehicle accident. She was 38 weeks pregnant with her first child at the time. Her uterus was ruptured and the fetus ejected into the abdominal cavity. The baby was stillborn. As a result of the damage to the mother's uterus, any further pregnancy was considered potentially life-threatening to her. In related proceedings, the evidence suggested that, at best, the mother could undergo 2 additional pregnancies. The mother required surgery for the abdominal injuries, suffered from periods of depression, and experienced pain in her neck, back, wrist, and abdomen. A jury, representatives of the community, awarded her the sum of $250,000. This is a more serious case. First, the way in which the damage was caused was not accidental, as in a car accident, but intentional, through surgery. Second, while further pregnancies in that case were possible, although very risky, here they were impossible. The government suggests that awards for injury, including psychological injury suffered by victims of sexual assault, are analogous to the award that should be made here. It points, for example, to a decision I made in 1991 in which I awarded $65,000 for pain and suffering, $10,000 in aggravated damages, and $50,000 in punitive damages to each of the 3 stepchildren of the defendant who had been sexually abused by him over a period of 2 to 3 years. It points to an Ontario case in which the court awarded $100,000 for pain and suffering, $75,000 in aggravated damages, and $50,000 in punitive damages. Other case law on the same subject is also submitted. As a matter of principle, I reject the approach advocated by the government. First, those decisions say nothing helpful about when it is appropriate to award the maximum amount for pain and suffering. There is nothing in the reasoning of those decisions that precludes the award of the maximum amount of damages for a sexual assault or a pattern of sexual assaults. Each case depends on its own facts. Not every case of wrongful sterilization will necessarily result in an award of maximum damages. On the other hand, there may well be a case one day where damages for the sexual assault will be awarded at the cap. Second, the sexual assault decisions do not deal with irreversible physical conditions, as is the case here. In summary on this issue, the plaintiff has established that she suffered catastrophic injuries as a result of the sterilization. As such, she is entitled to the maximum amount of damages for pain and suffering that the law allows. Aggravated damages. Ms. Muir is entitled to aggravated damages relating to the sterilization. These relate to the actions that caused her injury. The main aggravating feature of the sterilization is that it was done in the context of branding Ms. Muir as a mental defective, a moron. Thus, 2 serious blows were struck during the same sterilization operation. Ms. Muir's reproductive capacity was irretrievably destroyed, and she was physically and mentally branded as a moron. All of the testimony heard and the exhibits tendered during the trial bear witness to the catastrophic effect of being labeled a mental defective in Alberta in 1955 to 65. Mr. Kerr testified that he had to leave his parents in order just to work at the institution. He also gave evidence that it was difficult to recruit staff for the institution because of the low regard that professionals had for this mental hospital. Towards the end of the period during which Ms. Muir was at the institution, Dr. Levan was unable to buy a halfway house or group home in which to integrate trainees into the community because of community resentment. During this period, there seemed to be little understanding at PTS that there could be any rebound effect on children. On the contrary, once labeled a mental defective, the label would stick. The evidence establishes that the government acted in a high-handed way when it ignored its own legislation and sterilized her before she was ready to be discharged. If the government had followed its own legislation, Ms. Muir would never have been sterilized because she was never ready for discharge. Moreover, the evidence establishes that the conduct of the government in labeling Ms. Muir a mental defective was high-handed and oppressive. The evidence proves beyond a doubt that the government did not follow its own legislation, practices, and procedures when it labeled Ms. Muir a moron. It ignored advice from an expert that Ms. Muir's problems were emotional, not mental. It ignored the services of social workers and psychologists who might have assisted in obtaining information about Ms. Muir's background. It failed to require a compliance with the minimum safeguards which it had established, signature by a physician attesting to the validity of the admissions information, and psychometric testing. Before admitting her to an institution where she would be sterilized and stigmatized, the government acknowledged that it had obtained only cursory information. This was not an emergency situation. There were alternatives that were available, including foster homes and group homes. Ms. Muir has proved that the eugenics board that ordered her sterilization was not properly constituted under the legislation. Nevertheless, I consider this lapse to be due to a confusion by the government over the establishment of the various boards, rather than a deliberate action to avoid the terms of the different statutes. Therefore, I do not take the improper constitution of the board into account in determining any issue of damages. Ms. Muir asks for aggravated damages of $115,000. The evidence establishes her entitlement to that award. Punitive damages. Were it not for 2 important factors, I would have punished the province by imposing punitive damages. There is abundant proof on the basis of which punitive damages could be awarded. The government allowed the statute allowing sterilization to be deliberately misapplied. See especially the evidence of Dr. Thompson. The government ignored its own standards about when a sterilization was to be performed, when a trainee was being discharged from the institution. In this particular case, the government's failure to have abided by this particular requirement was particularly disastrous. Ms. Muir was never discharged by the institution. She would never have been sterilized if only the government's agents had followed the law that had been passed by the legislature of the province. Because of the government's own standards for sterilization were ignored, in Ms. Muir's case, the conduct of the government was more than negligent. It was intentional. The sterilization became an assault and battery. The trial has established that the government's approach to the sterilization of Ms. Muir was not an isolated situation. The government routinely operated outside of the law that permitted sterilization, that the agency routinely ignored its own administrative procedures and safeguard, routinely performed operations such as appendectomies that were not medically necessary. Despite the fact that the eugenics board claimed to have an IQ cutoff point of 70, persons above that level were approved for sterilization. Some of those persons had conditions such as spinal meningitis, hearing defects, or had been accused of criminal offenses. The board did not carefully examine each case that came before it. On the contrary, these critically important decisions about irreversible sterilizations, including salpingectomies and castrations, were in many cases routinely signed by the chairman and some other members of the board in advance of the board's decision. The board not only authorized sexual sterilizations and tolerated routine but medically unnecessary appendectomies, but also routinely authorized non-medically necessary procedures such as biopsies of testicular tissue. In some cases, the board directed a vasectomy only, but partial castration by unilateral orchidectomy was carried out. In some cases, the board authorized the hysterectomy or oophorectomy, removal of the ovaries, in order to eliminate menstruation in females. According to the language of one typical case, the female trainees were difficult to handle and keep clean during their menstrual periods. These operations were also ordered where female trainees masturbated or had lesbian tendencies. The defendant's actions were unlawful, offensive, and outrageous. Punitive damages in the amount of $250,000 suggested by Ms. Muir would certainly have been ordered if it had not been for the fact that the government allowed Ms. Muir to bring this action. It could have put an end to her claim. Her claim was made too late, and the government could have used this delay as a complete answer to all of Ms. Muir's claims. This deliberate abandonment of a complete defense is in the nature of an apology. Indeed, it is more than an apology. It is an amendment, a real effort to make things right. As a matter of public policy, this and other governments should be encouraged to recognize historical wrongs and to make fair amends for them. They should not be punished for doing so. I note also that the government recognized in 1972, when it abolished the Sexual Sterilization Act, that the former policy of government in this area was wrong. Then Premier Lougheed made the following comments in the legislature on April 14, 1972, when his government introduced the Sexual Sterilization Repeal Act. Quote, "I think the bill in its present form is most offensive with regard to the Bill of Rights, and in fact, this is one of the reasons it was introduced early. It is a very disturbing bill as far as I am concerned personally, and we feel strongly about it. But there is the one matter that I mentioned in answer to the first question that deals with the questions of parents being in a position to, in some way or another, create a voluntary sterilization under those particular circumstances. We are looking into that. We would welcome submissions on that point, but on that point alone. We are aware that there could possibly be an exception to the general point. We feel, as I mentioned, very, very strongly that the bill is offensive and at odds with the proposed Bill of Rights." End quote. Premier Lougheed's reference to the bill are in fact references to the then still existing sexual sterilization legislation. The repugnance of the Lougheed government to the state-controlled sexual sterilization was based on the government's assessment that the existing legislation struck at the very heart of individual rights in our society. Interventions of the type effected by the Lougheed government would be discouraged if a court were to impose punitive damages on a government that recognized a past social failure and tried to correct it. The government pleads that substantial punitive damages should not be awarded against it, in part because taxpayers would bear the true financial burden. With respect, this argument ignores the initial English approach to the award of punitive damages. Originally, there was only two situations in which punitive damages could be awarded. One where there was oppressive, arbitrary, or unconstitutional action by government, or two, where the wrongdoer planned to profit from its wrongdoing. In Canada, we extended the number of situations in which punitive damages may be awarded. That does not mean, however, that the initial basis for awarding damages has been abandoned. On the contrary, the government has become so powerful that recognition that it is subject to large punitive awards remains one of the few judicial ways in which the actions of government can be made to take into account the rights of individuals. Part 4. Is the government of Alberta liable for the confinement of Miss Muir? This court finds that the government wrongfully confined Miss Muir in the Provincial Training School for Mental Defectives. Her admission to and continuing confinement in the PTS were in violation of the statute authorizing such detentions. Her admission and continuing confinement was negligent. Her admission and continuing confinement were in breach of the government's fiduciary duty to her. The government argues that the same test that related to the sterilization does not apply to her admission to the school. It proposes that because the decision to admit Miss Muir to PTS was a less serious decision than a decision to sterilize her, a less serious standard of care should apply to the government's admission decision. In my view, this approach is wrong in principle. The decision to sterilize Miss Muir was irreversible. The decision to brand her as a mental defective, one of the, quote, moron menace, to deprive her of her liberty, to provide her with training only to grade 5 equivalency, these were all decisions that have affected Miss Muir throughout her life. Indeed, the very decision to detain as a mental defective was really the decision to sterilize. In summary, the decision to brand a young person as a mental defective in 1955 was an extremely serious decision, and the government should be held to a high standard in making such a decision. The high standard of which I speak is not a 1996 standard or a moral or religious one. It is the standard that was created by the legislation and the forms and procedures adopted by the institution itself. At a minimum, the government had to abide by its own standards. The government argues that Miss Muir was developmentally delayed and suggests that this is proved by her parents' application for her admission to the PTS. I reject that argument. First, it can be seen that Miss Skora should not have been accepted as a reliable witness about her daughter's development. PTS knew that Miss Skora had not kept appointments for the psychometric testing of Miss Muir when that testing had been recommended by the provincial guidance clinics. The government could easily have ascertained that Miss Skora did not, on some occasions, remember the months or the year of her daughter's birth. Tellingly, Miss Skora increasingly exaggerated the delay in developmental milestones. This is only to be expected of a parent who can no longer manage their child and who is attempting to have the child admitted to a mental hospital. The inherent problems associated with having a parent provide information about a potential trainee has been recognized by the PTS. The school normally required a physician's signature to confirm the evidence given by the parents. However, in Miss Muir's case, the sensible safeguard was ignored. The province says that there might not have been a single family physician to whom the PTS could have turned for information. But this is all the more reason, when the institution knew that this was a poor family that moved around a lot, for the institution to deploy the psychologist or social worker from its staff to make careful investigations of Miss Muir's background. This was not done. The government also argues that the 1957 IQ test confirms that Miss Muir was properly institutionalized. Its own evidence refutes this position. Dr. Keegan could not review the test form. It is therefore impossible to say whether scoring errors were made during the 1957 testing, just as errors were made during Dr. Calder's testing. More importantly, however, a single score based on an isolated test, when an independent psychiatrist had offered the opinion that Miss Muir's problems may be more emotional than mental, did not justify Miss Muir's ongoing confinement. Dr. Levin also knew, or should have known, that despite the Red Deer Guidance Clinic's determination that follow-up testing was required for Miss Muir, her parents never kept the appointment during which this testing would have taken place. This should have alerted Dr. Levin to the fact that these parents were not as reliable as was necessary where Miss Muir's interests were concerned. Dr. Levin authorized the admission of Miss Muir to an institution that would almost certainly sterilize a young female and would certainly stigmatize her as a mental defective, at a time when this was considered untreatable and when there was great fear of mental defectives in the community, without the psychometric evidence that was deemed by himself to be absolutely necessary. Dr. Levin did not even fill out the admission authorization until 4 days after Miss Muir's admission. Dr. Levin never ensured that repeated psychometric testing of Miss Muir was undertaken, although the school's own forms anticipated that this would be done. I accept Dr. Corpus's testimony about the standards that applied to institutionalization of mental defectives at the time in question. Quote, I would have expected that a commonly accepted standard of care would dictate that a full history of a child's home circumstances and a detailed assessment of their mental status and abilities would be obtained before admitting a child to an institution as mentally retarded. End quote. The standard of care practiced in justifying the plaintiff's classification as a mental subnormal and her subsequent sterilization fell substantially below the standard that I believe would have been expected of a specialist psychiatrist practicing at that time. 6 months after Miss Muir had been admitted, Dr. Levin received information from a psychiatrist, Dr. Hanley, that Miss Muir's problems were possibly emotional and not mental. Despite the fact that this information was directed to Dr. Levin personally, Dr. Levin did not then, or at any other time, review the situation relating to Miss Muir. Miss Muir lived at the residential school for almost a decade. Her evidence of the conditions in which she lived is largely corroborated by Mr. Kerr. The main incidents of this detention are as follows. Loss of privacy. As merely one example of the intrusive nature of the detention, Miss Muir's menstrual cycles were the subject of extensive record-keeping. Also, Miss Muir's correspondence from the school and the correspondence to her was monitored and regulated by the institution. Loss of liberty. As merely one example of the regulation of conduct while she was detained, is the evidence that she had to have written permission from the school authorities to go to different parts of the institution, such as helping in the laundry room or to help those inmates who were bedridden. Miss Muir testified that she was not allowed to leave the school premises except for authorized home visits until, at age 18 or so, she was sent out by the school as daily household labor in residences chosen by the school. Mr. Kerr's evidence on this point is especially telling because he is obviously very well disposed to Dr. Levin. Nonetheless, Mr. Kerr gave evidence of what was really happening at the provincial training school on the issue of detention, rather than what the reports were touting as open atmosphere. Moreover, the school determined which visitors Miss Muir could have. When a Mrs. Hepner, for example, offered to take Miss Muir during a Christmas vacation, the school would not allow the visit to take place. Imposition of institutional discipline. As merely one example of the extreme form of discipline imposed by the institution is the fact that, for punishment, Miss Muir was made to diaper adult inmates who had lost control of their bowel functions, and she was made to eat mush with a spoon. She was sent to wards with straitjacketed inmates where she scrubbed floors, did other similar work, slept in a small cement room with a rubber mattress, and ate out of a tin bowl. Administration of drugs to control behavior. Many antipsychotic drugs were administered to Miss Muir, despite the fact that she was not psychotic. Indeed, it appears from his publications in professional journals that Dr. Levin used Miss Muir and others as a means of testing the success of different drug treatments. Thus, the evidence clearly shows that the government is liable for Miss Muir's confinement. Part 5. Damages for confinement. Pain and suffering. Miss Muir was confined in a secure institution for nearly 10 years. The mere confinement in the institution stigmatized her. She suffered restrictions of her liberty and privacy, cruel punishment, and unauthorized drug experimentation. She received no counseling for her emotional problems and for her sterilization. How should she be compensated for this conduct? Donald Marshall spent 11 years in a Canadian prison after being wrongly convicted of a murder. He received an award of $225,000. A 32-year-old New Zealand man who spent 9 years in prison after being wrongly convicted of murder received an award of approximately $250,000. The government argues that prison cases do not provide an appropriate analogy for Miss Muir's situation. I disagree. The loss of liberty, the loss of privacy, the stigmatization, even the danger of a prison situation are very similar to the conditions of Miss Muir's detention. A New York State boy, wrongfully diagnosed as mentally retarded and detained in a state school for 91 years, was awarded combined damages of $1,500,000 US. Miss Muir claims damages of $250,000 for her detention. That is a reasonable proposal on the facts of this case, and I accept it. Miss Muir is also entitled to interest on this award, the interest to run from the day when she discharged herself from PTS. The government suggests that full prejudgment interest should not be awarded to Miss Muir because she started her lawsuit so late. I disagree. The government was put on notice, even before the Sexual Sterilization Act was passed, that it might be liable for damages for wrongful action taken pursuant to that act or related legislation. Therefore, this is not a situation where a party is given no notice that they might be liable to pay damages as a result of some act or neglect. Aggravated damages. Miss Muir claims an additional $125,000 for aggravated damages for her detention during the nearly 10-year period. This claim is not allowed for two reasons. First, in this case, the circumstances of the detention have been taken into account in awarding aggravated damages for the sterilization. Second, it is important to note that during the time she was there, Ms. Muir had no serious complaints about the detention. She considered that the other girls in her ward were just like her. This acknowledges that there was some advantages to the PTS when compared with her home life. At the school, she was not beaten every day, she had enough food to eat, and she had friends to play with. At the time, and especially in the early years of detention, she did not think that this was a crazy home. She thought of the PTS as if it were an orphanage. For these two reasons, no additional award is made under the heading of aggravated damages for detention. Defective education and training. Ms. Muir has established that, at the time of her detention, she had the capacity to go beyond grade 5. She had the capacity to absorb and profit from a higher degree of education and training than the government provided for her. The weight of the evidence establishes that during the time of her detention at the PTS, Ms. Muir had the ability to graduate from grade 12 in a vocational program. The evidence on which I rely to come to these conclusions includes the evidence at the time of her detention and evidence from her recent psychometric testing. The records of her pre-institutionalization did not suggest she had any problems with the schoolwork. Institutionalization was likely to have some depressing effect on her ability. She probably had knowledge that the testing in 1957 was preparatory to sterilization, and this knowledge probably had a dampening effect on her attitude to the testing. The verbal IQ testing in 1957, the testing which is the better predictor of academic achievement, was in the normal range. The 1957 testing is not entirely reliable because it was an isolated test, and because every isolated test has a margin of error around it. The 1957 testing is not entirely reliable because the individual scores are not available. The psychologist's report attached to the test is quite brief. Dr. Calder testifies, and I accept his evidence on this point, that one of the psychologist's comments, the one about visual motor skills, is nonsense. There may have been some other errors committed in this testing. In the early years at PTS, Ms. Muir was considered a good student who was progressing well through the curriculum provided and who was even given accelerated status. The formal reports beginning in 1959 must be treated with caution. That was the year of Ms. Muir's sterilization, and this was likely to have an effect on her schoolwork. Also, Ms. Muir was almost continuously under the influence of antipsychotic drugs. The weight of all the expert evidence relating to the IQ testing of Ms. Muir immediately prior to the trial suggests that, at the time, she had the intellectual capacity to complete a non-academic high school program. The evidence also suggests that there was little in Ms. Muir's experiences after leaving PTS that would have improved her basic skills. Working as a waitress was not likely to improve her verbal IQ. Therefore, this is not a situation of someone who was truly at a 64 IQ level in 1957 and who has more than a 20-point improvement today. In summary on this issue, the evidence establishes that Ms. Muir had in 1955 and has today normal intelligence, and that she is situated at the low end of the normal range. I also accept the evidence that educational attainment is a predictor of employment income. Higher levels of education are generally associated with higher levels of earnings. Nevertheless, I do not award any damages to Ms. Muir under this heading. 3 reasons underlie my decision. First, I am of the view that Ms. Muir has not distinguished between the measure of damages for tort and the measure of damages for contract. With respect, despite the able arguments she has mounted on the issue, I have concluded that she has proposed the wrong measures of damages for this conduct. She says that she would have earned more money if she had a better education. Even if that were so, the test for damages in tort is not the same as the test for damages in contract. In tort, the measure of damages is what would Ms. Muir's position have been if the wrongdoing had not been committed. In contract, the measure of damages is what would Ms. Muir's position have been if the government had done what it contracted to do. Ms. Muir has built a case for damages in this part of her claim on trying to force the government to do properly what it undertook to do. That is the wrong approach. There is no contract for Ms. Muir to enforce. I must consider what the situation had been if the government had not improperly admitted Ms. Muir to the Provincial Training School for Mental Defectives and kept her there until she was 21 years old. In addition to tort concepts, Ms. Muir also mentions liability arising from fiduciary duties. Even if fiduciary obligation was the right cause of action in this part of Ms. Muir's claim, Ms. Muir would still not be entitled to damages for loss of past and future income. Although Ms. Muir has proved breach of fiduciary duty, she would have had to prove, in addition, that the breach of fiduciary obligation has caused her a loss. For the reasons given below, I conclude that she has failed to prove a loss of past or future income. Finally, I have considered whether the government as a public body had any particular standard to meet in its role as a guardian and educator. I have concluded that there is no such liability here because the government carried out the training obligations that it had set up for itself. This is therefore not a Kamloops situation. Second, I do not accept the evidence presented on the loss of income. Ms. Muir's experts have predicted an unreasonably high loss of past and future income. One problem is that it has been difficult to properly estimate what Ms. Muir has earned since she left PTS. Given the fact that a waitress might be expected to double her salary in tips, and that a building manager receives benefits that are the equivalent of income, it is very likely that Ms. Muir's income over the years is underreported. This would exaggerate her loss. An additional concern is that Ms. Muir's experts assumed that she would have achieved a grade 12 level much too early. She could not finish 10 years of schooling in 8 years. This error exaggerates her loss. Moreover, because Ms. Muir missed some of the fundamentals, it should not be expected that she would catch up in the way anticipated by Ms. Muir's experts. This error also exaggerates her loss. Another component of the project loss which I cannot agree is the assumption of Ms. Muir's continuous participation in the workforce. We know that participation is a very important component of the overall income picture. We know that Ms. Muir did not participate in the workforce every year after she left the PTS. Assuming continuous participation exaggerates her loss. Third, I cannot accept Ms. Muir's assumption that her mental potential will be realized at school and in the workplace. This is the most serious flaw in her argument for damages for lost wages. It applies to every one of her potential causes of action relating to training and education. Statistical evidence about potential is useful evidence if no other evidence is available. The evidence here is that IQ tests by themselves are not, except at the extremes, very good predictors of years of education that will be completed. Awards in lawsuits are not based on possibilities, but on probabilities. Where specific evidence relating to a particular case is available, that evidence will be more relevant than statistics. I cannot be satisfied that Ms. Muir would probably have completed a non-academic high school program, even if it had been made available to her. Although Ms. Muir had and has the necessary mental ability to obtain a non-academic high school certificate, she also has severe maladaptive behaviors. She had emotional problems that were severe enough to interfere with her schooling up to the time of her admission to the PTS. Those emotional problems were likely to have some effect on her future education. By the time Ms. Muir came to the PTS, she was approaching puberty. The expert evidence in this trial establishes that girls who are entering that important stage of menstruation may well be distracted from the onerous work that would be required to overcome the failure to have put down good educational skills in earlier years. As Ms. Muir's experts concede, and as hard as a fact as it may be for Ms. Muir to accept today, family circumstances are an important predictor in determining how much education a person will get and what kind of work they will do. What Ms. Skora did in terms of employment and what Ms. Muir's siblings achieved are predictors of what Ms. Skora would have done if a non-academic high school program had been available to her. There's no suggestion in the evidence that Ms. Skora would have supported Ms. Muir in any quest for a high school education. There is nothing in the achievements of her siblings that make it probable that Ms. Muir would have completed the education and maintained the employment levels that are predicted for her. In summary, Ms. Muir had and has potential for making higher levels of income than she is making now. However, she has not proved that it was probable that she would achieve those levels of income. Therefore, no award is made under this heading. Part 6. Costs. If the parties are not agreed on costs, they may be spoken to within 30 days of the release of these reasons. Judgment for the plaintiff.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.